Please, today we are, that is no, I told you, I explained High Court of India. Am I right? And then I had given some of the questions related to High Court of India. High Court of state, not High Court of India, High Court. And you see, there are different types of jurisdiction for the High Court. First jurisdiction is called what? Original jurisdiction. Second jurisdiction is called what? Appellate jurisdictions. These are the two important jurisdiction of High Court of each state. You see, when we study this High Court to settle the dispute for the first instance. What are the cases that the High Court can settle? First case is what is called, which case settle for the instance? Original jurisdiction. Which cases it can have these original jurisdictions? Which areas it has the original jurisdictions? Civil cases, and then criminal cases, then what is there?
Sir, advisory jurisdiction.
Advisory jurisdiction is not there in the syllabus, but it has advisory jurisdictions, but it is not there in the syllabus. I told you mainly what is called it has an original jurisdiction. Matters related to state revenues, civil cases, cases regarding the wills and divorce and marriage and company laws. Every High Court has a right to interpret the constitutions. Every High Court has a right to issue writs when the fundamental rights are violated. You see, when the fundamental rights of an individual is violated by the action of executive or by what is called or by laws passed by the legislative assembly. So in such a cases, if that is not the person or individual move to the High Court, the High Court can also issue writs. So the High Court has a right to issue writs to re-establish the fundamental rights whenever the fundamental rights are violated or that is bypassing law or actions. And the second one is the High Court has a power to interpret the constitutions. And because High Court also got the power, and how it would guard the constitutions. It would guard the constitution by judicial review. Judicial review, I told you, what is a judicial review? Whenever a law is passed by the state legislative assembly, or this law is against the constitution or letter and spirit of the constitution, this High Court can declare it as ultra vires. And this power of the High Court is called what? Judicial review. So that is why original jurisdictions has that is extending towards the election related to MPs and MLAs. All these are what is called a major original jurisdiction, or the areas where the High Court can exercise the original jurisdictions. And next one I told you, appellate jurisdictions. High Court, there is no appellate means what is called, it is a power of a High Court to accept appeals against the decisions of district courts or in the civil cases or criminal matters by the session court. I told you in a district there are two types of court. First court is called what? A civil court. The civil court is in the district is called a district court. And the judge of the civil court in the district is called a district court judge. And second one is criminal court. The highest criminal court in the district is called a session court. The session court, highest criminal court. And the highest judge of the district in the matter related to these criminal cases is called a session judge. So please remember this one. Yes.
Yes. नहीं 8:30.
Okay, then what is called, next one is appellate jurisdictions. I told you civil cases. all the matter concerning the land revenues, cases that is where the blatant injustice has been committed by the tribunals. In criminal cases against the judgments of the session judge, what is called assistant session judge or additional session judge, and where what is called the sentence of imprisonment is more than 7 years. Against the judgment of assistant session judge, chief metropolitan magistrate, where the imprisonment has been more than 4 years. Against what is called a state, where the order of acquaintance is passed by the session. If a person is what is called punished, person is sentenced to death. In such a case, if a person is sentenced to death, then this person's case has been acquainted by the session judge, the district session judge. Then in that case, the High Court can take the case, and then the High Court can examine this or confirm, that is confirm whether this sentence to death is right or just injustice in a matter related to justice or injustice. So that is why this is also what is called the power of a High Court. And then I told you what are the functions of the High Court. When we study these functions of the High Court, we can find what is called, it has a administrative function is there, mainly what is called a main function is a settlement of dispute. Main function of the High Court is settlement of dispute. Second one is enforcement of fundamental rights. Third one is advisory jurisdiction. High Court can advise the government department, state government department, not the president. President, that means Supreme Court can give advice to president if the president seek advice of Supreme Court. And here the governor can ask opinion of the High Court. Any matter related to public importance or any matter related to more legal issues. In such a case, so the governor can seek the opinion of the High Court. So High Court has an advisory jurisdiction. Then the revisory jurisdiction is also there. High Court can call for the record of a case which has been decided by the subordinate court. Because if a subordinate court has decided a case, and that case that is not coming under the subordinate court, or it needs more interpretation of the laws, then in such a case, that a case can be what is called the High Court feels that the subordinate court has exercised the jurisdiction not to vested upon it. In that case, the case can be taken to the High Court, review the case, and take appropriate action on it. And that is why it has what is called a revisory jurisdiction. Revisory jurisdiction means violation of the principles of natural justice and injustice or error, that is of a law apparent in the face of the record. And all these are called what revisory jurisdiction. Revisory jurisdiction means High Court can call for the record of a case which has been decided by the subordinate court. A case has been decided by the subordinate case, and this case should not be settled by this subordinate court. And in such a case, the High Court can take this case to the High Court, or the High Court can examine this case, and the High Court can revise this order given by the subordinate court. And this is called what? Revisory jurisdiction. And it has also judicial review. What is a judicial review? High Court has a power to what is called examine the law passed by the state legislative assembly, whether it would be against the constitution or not, the violation of the constitution or not. In such a case, because violation of the constitution is a very important matter because it has been granted and guaranteed by the constitution. In such a cases also, this High Court can what is called issue writs, or High Court can declare such a law as ultra vires. This is called what? A judicial review of a High Court. Then High Court is called a court of record because whatever the judgments or orders given by the High Court should be preserved as a record to be preferred by the courts in the future cases. You know, it is the highest court in the state. Whatever the jurisdiction given or whatever the orders given by the High Court should be recorded, because whatever the judgment or whatever the orders given by the High Court, it would be considered by the lower court in the same matter or in the same cases. So that is why it would be recorded. Suppose whatever the punishment given by the High Court, and this punishment related to particular case should be recorded. So that is why in any lower court case that handles such a cases, the lower court can also give the same punishment given by the High Court. That is why the law laid by the High Court is binding upon all the subordinate courts. Whatever the law means, whatever the judgment, whatever the order given by the High Court is known as a law. And this law is binding upon all the subordinate courts of the state, because it is the highest court of the state. That is why whatever the judgment, whatever the orders given by the High Court should be recorded, and it should be binding upon all other subordinate courts, because they have to follow the same decisions or the same judgment for the similar cases which had been given by the High Court earlier. So that is why this High Court is also known as a court of record. But these are not there in the syllabus. This is not in the syllabus, I think. Then you see, now we are going to study about what is called a Lok Adalat is there. Lok Adalat. You know, Lok Adalat means it is a people's court. And people's court, and it has been practiced in India. It has been recommended in India by Justice P.N. Bhagavati. And it was what is called set up by law, the Legal Service Authority Act of 1987. So please remember, Lok Adalat means it is a people's court. And on the recommendation of Justice P.N. Bhagavati, Lok Adalats were set up by Legal Services Authorities Act 1987 as a legal forum to provide legal aid and quick justice to those who are not in a position to engage lawyer or hear the expenses of legal proceedings. You see, some cases, if some dispute comes between any two persons, so they can move to the court. But the court will take a time to settle case. Each hearing, you have to, you have to arrange your advocate for arguing your legal matters in the court. So you have to pay money to this advocate. So for each hearing, he would ask money. So fees, you have to pay. But it is what is called expenses. It is an expensive way. It is an expensive way to settle your matter, because going to the court would be what is called adjourn the cases, and the court would take what is called the years to settle the cases. That is why you want to get to what is called quick justice. So in such a cases, what is called you can go to Lok Adalat. Lok Adalat can settle such a dispute by calling these two people. And on the basis of what is called compromise, they may settle the cases. And compromise on the basis of compromise. And when they what is called settle these cases on the basis of compromise, but they follow what is called justice. They follow justice, principles of justice. And then they can give what is called a quick justice to the people. And that is why those who are not able to pay the fees to the legal cases, such a people can go to the Lok Adalat. And the Lok Adalat can give what is called speedy justice. So that is why it has been what is called, it has been known as a people's court. It has been known as a people's court. And why it is known as a people's court? Because it is a legal forum. It is a legal forum. and it can provide legal aid as well as quick justice to those who are not in a position to engage lawyers or hear the expenses of what is called bear the expenses of the legal proceedings. If I am not able to bear the expenses of legal proceedings, if I am not able to get an advocate, in such a cases, I can move to the Lok Adalat. In the Lok Adalat, what they will do, all the decisions would be taken by the Lok Adalat would be based on compromise. That is a very important point you have to understand. And based on compromise, but they never, what is called, never leave the principles of justice. They follow the principles of justice. And so that is why Lok Adalat is a people's court, and it relieves the courts of heavy block of cases. You know, in each court, when you see number of cases are pending, and so it would take a time to settle the dispute, and it would take years to settle the dispute, and that is why the Lok Adalat can reduce the pressure on court. And you know, number of cases are there. Again, you are going to the court, the cases would be pending because former cases would be settled first. After that, only your cases would be settled. But you know, that is why this case, this Lok Adalat can reduce the pressure on what is called this other courts. And it can eliminate high cost and delays imparting justice. That is why this Lok Adalat is very important. So please write, what is a Lok Adalat? What is a Lok Adalat? Lok Adalat means people's court. Lok Adalat means people's court. Lok Adalats were set up. Just a point, Lok Adalats were set up by Legal Services Authorities Act 1987.
Sir, by Legal
Authorities Act were set up by Legal Services Authorities Act. Legal Services Authorities Act 1987. As a legal forum to provide legal aid and quick justice to those who are not in a position to engage lawyers, or bear the expenses
Sir, not in position to.
not in a position to engage lawyers or bear the expenses of legal proceedings. Have you written? Lok Adalat settled disputes Lok Adalat settled disputes through negotiations arbitration and compromises based on the principles of law and justice. Next one, since a decision of the Lok Adalat is based upon the consent of both the parties,
Sir, based upon
the consent of both the parties. Suppose if I have a problem with somebody else, both the parties consent, only this Lok Adalat can settle the cases. So, what you have written? Based upon the consent of both the parties to the dispute, comma, no appeal can be made. No appeal can be made after the Lok Adalat has settled the dispute. Then advantages of Lok Adalat. Advantages of Lok Adalat. Lok Adalat plays important role Lok Adalat plays important roles in the settlement of family feuds
the settlement of
family feuds, F-E-U-D-S, family feuds,
Sir, F-E?
U-D-S, family feuds. Family feuds, comma, minor cases of assault,
Sir, after fuse what, sir?
feuds, comma, dispute between neighbors, and minor cases of assault or and injury by settling the dispute through
and
between neighbors and minor cases of assault and injury by settling the dispute through compromise. Here what is called Lok Adalat can settle the dispute. What are the dispute it can settle? Family dispute, with divorce cases, family dispute, or between the families. And the second one is what is called the dispute between the neighbors, based on what is called a boundary, based on what is called a property, etc. And based on what is called minor cases of assault. That means cases related to what is called assault. Assault means what is called sometimes what is called kind of what is called damaging their personal dignity, etc. And in that cases, that means you can move to the court. This is a Lok Adalat court. But Lok Adalat court settled the dispute by calling these both the parties, not by single party. That is why whatever the cases settled by the Lok Adalat, it would be based on compromise only. So that is why I told you, after the settling of this case by the Lok Adalat, never be taken to a appeal, because appeal cannot be made. Why? Because this case has been settled through compromise. If I have a problem with somebody else, with the compromise of these both parties, we have settled the case. Then why should I go for appeal? So no appeal can be made. And the second one is what is called, sometimes accidents happen. Suppose when during the accident cases, what is called insurance would be there, and that case can be taken to the Lok Adalat, and immediately you will get to what is called justice. Otherwise, you have to wait for years if you go to the normal court. If you go to the Lok Adalat would call both parties, and then the Lok Adalat tried to settle this case. And victim would get a compensation. And the victim should be ready to compromise with this the settlement done by this Lok Adalat. And whatever the compromise done, and this after the Lok Adalat compromise or settling the dispute, we cannot go to the next court for as an appeal. So no appeal can be made after settling the case by the Lok Adalat. Then next point, you write. Next point, Lok Adalat deliver fast and inexpensive justice. Deliver fast and inexpensive justice. Next point, Lok Adalat can reduce the workload of other courts enabling them to deal with the
Lok Adalat can reduce.
the Lok Adalat can reduce the workload of other courts, enabling them to deal with the more serious matters. Next point, Lok Adalat promote the social justice. Lok Adalat promotes social justice by providing legal aid to weaker sections of the society. Weaker sections of the society. Next one, what are the differences between the district judge and the session judge court? District judge and the session judge. You please make a columns. You write the differences. So it is also there in the syllabus. Differences between the court of district judge and court of session judge. First point, court of district judge. You have to make the columns. First point, it is the highest civil court of the district judge court of the district judge.
What, sir?
Court of the district judge columns, first you write, it is the highest civil court. It is the highest civil court of the district. In the session court, you write, it is the highest criminal court of the district. It is the highest criminal court of the district. Second point, in the court of district judge, it is presided over by the district judge. It is presided over by the district judge. Next, in the session court, it is presided over by a session judge. Next point, district judge decides civil cases. In the court of district judge, you write, the district judge decides civil cases related to land, property, money transactions, guardianship,
Sir, what?
guardianship, divorce, etc. Then session judge. The session judge decides criminal cases,
What, sir?
the session judge decides the criminal cases
Session judge.
like murders. Here there is no sound system is going on from the school. That is why I am little disturbed. Are you hearing?
Yes, sir. Yes, sir.
Very good. So please, that is sound system is, they are checking the sound system, that is why. Besides criminal cases like murders, theft, pickpocketing, etc.
What, sir?
Pickpocketing. And in this capacity, he maintains law and order. In this capacity, he maintains law and order. He maintains law and order and supervises the collection of revenue taxes in the district. In the session judge, the sessions judge, doesn't perform any administrative functions. You see, the session judge doesn't perform any administrative functions. First of all, you have made the columns. It is the highest civil court of the district. Which one? Court of the district judge. And the session court is the highest criminal court of the district. Please understand. Session court means highest civil criminal court in the district. And the district judge means, or district court means, it is the highest civil court in the district. And next point is what is called district judges decide cases related to land, property, taxes, money transaction, guardianship, marriage, divorces, wills, etc. And the session judge decides the criminal cases, and like murders, theft, then pickpocketing, etc. And the district judge acts as a deputy commissioner. You see, he can act as a deputy commissioner or district collector. So each district collector is a district judge. Please remember that. Each district collector is a district judge. And he can, what is called, in this capacity, he can maintain law and order in the district. And also he can supervise the collection of revenue and taxes in the district. This is also his capacity. And the session judge does not perform any administrative functions. So session judges, that is why, sometimes you have seen their vehicles written session judge. Sometimes written district judge. On there is a vehicles in front, they have written nameplate. But it's called district judge. So district judge means, you must understand, he is the highest civil judge in the district. And he is what is called similar to district collector. That is why he can, he can perform some duties like what is called district collector or deputy commissioner, so that he can maintain the law and order in the district. But the session judge is not having any administrative functions. He has to decide the case related to all the criminal cases, not the civil cases. But you remember, this district judge and this session judge, both are appointed by the governor only. Both are appointed by the governor with the consultation of Chief Justice of the concerned state. Okay. So, district judge is there or session judge is there. Both are appointed by the governor of the state with the consultation of the Chief Justice of the High Court of the concerned state. Please remember. But you see, you have to understand the differences between this court of civil cases and court of criminal cases. The highest court of civil case in the district is a district court. The highest criminal court in the district is a session court. Please remember. And the district judge handles all the cases, the matters related to land, property, marriage, divorces, will, guardianship, etc. Session judge decides the cases related to criminal cases. Means murder, theft, sometimes dacoity, or what is called pickpocketing, etc. And the district judge can act as an administrator of the district. That is why each district collector is called as a district judge. Each district collector, because he can act as a district collector, he can act as a deputy commissioner, and so that he can maintain law and order in the district itself. But the session judge does not have any administrative functions. But both are appointed by governor of the state in consultation with the Chief Justice of High Court. These are the major topics related to what is called this High Court. Have you got it?
Sir,
Yes.
sir, a district judge acts as
District judge acts as district collector and deputy commissioner.
and sir, session judge does not act like anything, sir.
No, he does not have any administrative functions. Have you got it?
Yes.
So that is a main difference. So that is why your DC is there. DC is a district judge, not a session judge. Got it?
Yes. Yes, sir.
DC does not have any power to handle the cases related to criminal cases. Have you got it?
Yes, sir.
But your district collector has a power to settle the dispute related to land, property, divorce, marriage, will, guardianship, etc. Have you got it?
Yes, sir.
Yes. So understood now?
Yes, sir.
Yes.
Okay. Please study all these points today. Then the next class I will take what is called tomorrow. I will take what is called First World War. Okay, got it?
Good night, sir.
Good night.
Thank you, sir.
Thank you, sir.
Okay, welcome. Okay. Good night.